This presentation is entitled Statutory Compliance for the Use and Production of Medical Cannabis in Florida. There are 6 areas of statutory compliance that we will be discussing today. First is the authorization for an attorney to provide legal advice and assistance with medical cannabis. The second is the authorization for a physician to provide an order or prescription for cannabis. The third is authorization for a person with a prescription to possess cannabis. The fourth is authorization for a patient to manufacture cannabis for medical use. The fifth is determining law enforcement compliance. And the sixth area is public and media acknowledgments. Now first, the authorization for an attorney to provide legal advice and assistance with medical cannabis comes from the Florida Bar. On May 23rd, the Florida Bar created a policy that provides immunity for attorneys who advise or assist clients in conduct related to medical marijuana. Now, attorneys must provide information also regarding federal law. Now, on May 23rd, after the discussion, the Board of Governors approved the policy by voice vote. Section 2 is related to the authorization for a physician to provide an order or prescription for cannabis. Now, on December 15, 2014, President Barack Obama signed into law House Resolution 4660, which defers all matters related to medical cannabis to respective states which have existing laws. As you can see in this outline, Florida is clearly listed as one of those states. Now, this law passed both the U.S. House and Senate in May 2014 prior to the enactment of the Low THC Act. Now, Florida Statute 893.05 is the statute that allows a practitioner other than an optometrist to prescribe or order a Schedule I controlled substance. Now, paragraph C shows that cannabis is a Schedule I controlled substance, while paragraph D outlines the definition of cannabis, which includes any parts of any plant, whether growing or not, and every compound or manufacture. This means that the plant may be prescribed to a patient. Moving on to paragraph E, our state legislature has provided language that specifically authorizes a citizen to use any mode of treatment they feel necessary for treating human disease or other conditions. Now, paragraph F outlines the Department of Health rules on prescribing controlled substances. Now, as you can see, physicians shall not fear any disciplinary action so long as their prescription is for a legitimate medical purpose that is supported by proper documentation. This is Representative Matt Caldwell, who is one of the co-authors of the 2013 Compassionate Care Act. Representative Caldwell also created the practice of optometry in 2012. Please listen to the following statements that were made by Representative Caldwell during a conversation that was held May 5, 2014 regarding a physician's right to prescribe a Schedule I controlled substance.
We don't speak, we have never spoken to, in state law, a prohibition on prescribing Schedule I. We've only defined what those are, and then it's been up to the practitioner to be competent and to follow federal law in as much as there was some. And yes, when we did the optometry bill, the main objection from the MDs was that optometrists should not be given the discretion to have even the possibility of prescribing Schedule I and II. So,
now that we know that it may be prescribed, the question is how is it possessed? Now, once again, federal law has deferred to state law in Florida, and the first statement in paragraph 1 of 893.13 provides exemptions from criminal penalty for certain purposes. Now, one exemption found in paragraph C is pursuant to a prescription or order by a practitioner. Paragraph D provides exemptions from all penalties found in 893.13 if the substance is for medical or scientific use, while Chapter 499 authorizes possession if it is prescribed by a practitioner licensed to prescribe the drug. Here's a clip from Dr. Jessica Spencer that was aired August 19th, 2014 in Jacksonville. Dr. Jessica Spencer was the spokesperson for the No on 2 campaign that partnered with the Florida Sheriff's Association in defeating Amendment 2.
We already have medical marijuana here in this state. We have a Florida statute that allows for medical necessity. So that is why there are several individuals already that have used marijuana or have been caught with marijuana, et cetera, and they had a recommendation from their doctor. We don't need Amendment 2 for the, quote, medical marijuana. We already have it. We already have a Florida statute in place that protects those individuals, and there's also medications that they're working on right now for these different illnesses, and you can find them on clinicaltrials.gov. And anyone, from our camp or anyone that I know would be more than happy to help those families get those medications that they truly need.
Okay, Dr. Spencer, thank you so much. And we're going to continue this discussion right after the break. We're going to have Elwood Thompson here to talk about why he is pushing so hard to have Amendment 2 passed. We're also going to hear from a First Coast mom. We're back right after this.
For a physician to prescribe any medication, it must be determined that the medicine is the least harmful alternative to treat the patient. This is a chart that was prepared by the National Institute of Drug Abuse regarding the dangers of popular drugs. Of course, these are recreational, but mind you, this was known that marijuana is the safest recreational drug all the way back to 1994. This chart represents the statistics that were published by the Florida Department of Law Enforcement in 2013 regarding the drug-related causes of death. As you can see, opioids account for almost half of all drug-related deaths, while cannabis has never caused a single death according to the same report. Now, opioids are the #1 prescribed medication in the state of Florida, yet cannabis provides similar results in treating severe pain without any possibility of death related to overdose or accidental ingestion, making it the safest alternative available for a patient in Florida. Here is part 1 of the drug death report. This report provides the data necessary to determine the safest medication available. Now, as you can see, alprazolam is responsible for over 600 deaths alone in 2012. Alprazolam is the active ingredient that's found in Xanax. Moving on to part 2 of the drug death report, you can see here that opioids cause thousands of deaths. However, cannabinoids, found underneath in the other category, has not been a single cause of one. The next area which seems to be the most controversial is the manufacturing of cannabis. Now, once again, the federal government has deferred to the state of Florida on this issue. As mentioned earlier, paragraph 1 of Chapter 893.13 provides certain authorizations. Now, as you can see in 1351, cannabis is clearly named in that statute. However, this statute provides exemptions as well based on certain authorizations that are found in 893.13. This is because the definition of cannabis includes the manufacturer. The definition of manufacture means the production, preparation, and cultivating of cannabis. Based on the language found in 893.13.6a, if a person has a prescription to possess cannabis, that person would have the same authority to manufacture cannabis for their own use based on the clear definition of cannabis. Now, the manufacture would then be lawful because the penalties do not apply to medical or scientific use. Now, paragraph D outlines the definition of medicinal drug, which means substances commonly known as prescription or legend drugs that are required to be dispensed pursuant to a prescription. Now, paragraph E provides the exemption from Chapter 499, which is the Drug and Cosmetic Act, since there is a valid prescription to manufacture. This is a video clip from a debate between Supreme Court Justice Ken Bell and Attorney John Morgan that took place in October 2014, just prior to the vote. Here, Justice Bell clarifies the fact that a patient does have the right to cultivate cannabis with a prescription. Please take a look.
I wish I had time to talk about OxyContin. I had the privilege as a circuit judge where I served for 12 years to sit in the first case of the country where a doctor was convicted, and I sentenced him to 54 years in prison for his OxyContin subscription. Ran a pill mill, Santa Rosa County, Milton, Florida was second only to New York City in the distribution of OxyContin for a pill mill. I've seen the effect. 9 people OD. He was convicted of manslaughter for 4 of them. I understand it, and I'm against Amendment 2. Why? In the federal question, we don't even need the amendment, and I don't know what Mr. Morgan's answer to this question is, and I'll yield to him, Professor, if you want me to, but law students, 893.136A puts into law what was case law as the medical necessity. A physician can prescribe marijuana, and you can actually grow it as the individual, and by rule, the physician's immune from liability for that. There's no need for this amendment if you want to get marijuana. If this passes, the individual will not be able to grow their own marijuana. It's not needed. So the doctor has protection where the liability for federal, I'm not sure.
Section 5 outlines the responsibilities of law enforcement while investigating the possession or manufacture of a controlled substance. Paragraph A is vital due to the severity of penalties for possessing unlawful controlled substances. This law says that if there are statutes that are susceptible of differing constructions, the construction that must be used must favor the accused. Now, the first line in paragraph 893.13 provides exceptions from penalty, while paragraph C allows for the lawful possession of a Schedule I controlled substance. Paragraph D provides exemptions from trafficking laws if certain exemptions are met, and paragraph E prevents officers from acting in a manner exhibiting wanton and willful disregard for human rights, safety, or property. Section 6 discusses public acknowledgments of medical cannabis. Now, if you've already seen in the first 3 paragraphs here, State Representative Matt Caldwell has already stated that a physician can prescribe a Schedule I controlled substance, and Dr. Jessica Spencer, who worked hand in hand with the Sheriff's Association and the No on 2 campaign, discussed this as well during a debate with United for Care. We've also seen the recorded statement by Supreme Court Justice Ken Bell during his debate with John Morgan. And we also have 2 others, one being a news article that was written by the Gainesville Sun that quotes Alachua County Sheriff Sadie Darnell. Also, we have a recorded statement by Dr. Jessica Spencer, who was sitting on a panel with Volusia County Sheriff Ben Johnson on October 5th, 2014. And let's get to those. The statement was by Sadie Darnell, the Alachua County Sheriff, and this states that Amendment 2 was unnecessary and medical marijuana was already legal in Florida with a doctor's authorization, and that her basis for the statement is a section of Florida Statute 893.13, which we've already discussed, that states a person may not be in actual or constructive possession of a controlled substance unless such controlled substance was lawfully obtained from a practitioner pursuant to a valid prescription or order of a practitioner while acting in the course of his or her professional practice. Here's a story of somebody here in Florida who has been personally affected by this issue.
First Coast News' Keitha Nelson has a story of one First Coast mom who says medical marijuana is the key to helping end her daughter's suffering.
A mother's touch, a simple kiss, and a complicated solution.
We want medical marijuana for her. There's really nothing left other than new medicines that are coming out every day, but the side effects are pretty horrific.
With not even a decade behind her, little Christina has undergone 3 brain surgeries, taken 16 different medications, and traveled to 3 countries for stem cell treatment. Born with epilepsy, seizures, uncontrollable, have become a constant in her life.
It's very difficult to watch.
Tired of watching her child suffer, Clark is making a bold move, suppressing her fears, ready to provide Christina with a drug now embroiled in a controversial fight in state.
They don't have to suffer. Their children do not have to suffer.
Christopher Ralph, a legal administrator for Health Law Services in Jacksonville for the past 6 months, has reached out to law enforcement agencies, spreading the word about the Florida Doctrine of Medical Necessity.
Florida's case law says that you have to, if you have a condition that you're suffering from, and this is the medication that's least harmful to you and it's effective, this is what will work.
To summarize, Florida law provides authorizations for a physician to provide an order or prescription for cannabis, authorizations for a person with a prescription to possess cannabis, authorizations to manufacture cannabis for medical use, as well as provisions for law enforcement to determine whether somebody is in lawful compliance or not. Health Law Services now specializes in this area of law, and this is thanks to Florida bar rules and regulations that were voted on May 23, 2014, that authorizes an attorney to provide legal advice and assistance with medical cannabis. And that concludes this presentation. For further information, please contact Health Law Services directly.